All right, we'll call our next case, Wiley versus Hancock Bank.
Good morning, sir.
Good morning.
You may proceed whenever you're ready.
May it please the court. My name is Ryan Gantos, and I represent Sarah and David Wiley, who are the appellants on this appeal, who were the defendants in a lower court matter, which was an action for foreclosure. They had final judgment entered against them at the conclusion of a non-jury bench trial on May 7th, 2012. At this point, I'd like to respectfully request 5 minutes for rebuttal. There were two primary issues raised on this appeal. The first issue has to do with the appellees, who was Hancock Bank, the plaintiff at the lower action, their ability to enforce the promissory note and mortgage, or their capacity as the purported holder of the note that was the subject of that action, and whether they presented competent evidence to prove by the preponderance of evidence that they are in fact the entity entitled to enforce the promissory note that was the subject of the action at the lower level.
I know you didn't write the brief, right?
No, I did not, Your Honor.
Because under your standard of review, you set out every standard of review that exists in the jurisprudence of appellate practice.
Yes, Your Honor. I did notice in the initial brief it was not very clear. It's my position that issues pertaining to standing are a de novo review. I do...
Did you notice there was also no actual statement of facts in the brief?
I did notice that as well, Your Honor. And I do apologize, and if the court would like, I would go over the facts here before.
Well, that's yeah. The other aspect of the brief that's a little noteworthy is that there's not one record cite in the totality of the brief to the record on appeal.
And Your Honor, again, I do apologize for that. The standard review was properly outlined also in the answer brief by the appellee's counsel.
So you'd like to rely upon the answer brief?
Well, I would like to clarify that the issues pertaining to standing are a de novo standard review, and then appellee's counsel was gracious enough to provide the standard review for the abuse of discretion standard as to the issues of admissibility of evidence at the trial level. We do submit to the court that plaintiff did
trust if you wrote the brief next time around that we'll see a little bit better work product?
Absolutely, Your Honor.
Okay.
The first issue does have to do with the appellee's standing to enforce a note mortgage, like I said, and this court has addressed that issue before in G versus U.S. Bank National Association, which was a District Court of Appeals opinion in 2011, which was raised in the brief, as well as the BAC Funding Consortium versus Jean-Jacques. And both cases stand for the proposition that plaintiff must present competent evidence to support its allegation and its complaint that it's the holder of the note and mortgage. Under the Florida Uniform Commercial Code 673, Section 3011, it identifies who can enforce a promissory note. It says that a holder may do so. And under 671-201, subsection 21, it explains that a holder is an entity or person in possession of an original note, along with an endorsement that is either payable to bearer, which is also known as an endorsement in blank, or a special endorsement to the entity who is attempting to enforce it. What we have in this case was the original note was filed April 28, 2011. It was also submitted to the court and accepted into evidence at the non-jury bench trial. And the copy of the note provided, however, does not bear any endorsement, either in blank or special endorsement to Hancock. What the appellee's contention was at the lower level, and in its answer brief, is that it submitted what it called an allonge to note.
Did you even argue that to the trial court? Do we even have a record to show that that was an argument?
It was argued, Your Honor.
Well, is it in the record that that was argued?
It is, Your Honor, and if the allonge to note was introduced as Exhibit 7, and it's found at transcript page 100 of the record.
Did you argue it was invalid?
Yes, Your Honor. In fact, there were.
Where in the record do we see that argument? Is it anywhere in the record?
Your Honor, you'll find it at transcript page 100, the description of the validity of the allonge as it was filed. There's a discussion as to whether it was actually attached to the physical original note. I don't think that there was a discussion as to the actual provisions of the UCC which control the signatures.
What is your argument based upon? I mean, you don't dispute that the original holder of the note, People's First Bank, went under and was taken over by the Office of Thrift Supervision, or FDIC.
Our contention...
You don't dispute that, do you?
No, I do not, Your Honor.
And as a result, those government entities had whatever assets that People's First had, they had those assets then to dispose of, correct?
Yes, Your Honor.
And I thought the allonge in this case had, or separately, they introduced a power of attorney executed by an officer of the FDIC, or the Office of Thrift Supervision, I forget which one, that authorized whoever it was that executed the allonge to do so on behalf of that governmental entity. Is that correct?
That is correct, Your Honor.
So if that's the landscape, now help me focus on exactly what the defect is in the transfer of, I mean, ultimately it starts with People First and allegedly ends up with Hancock. So help me understand specifically where the alleged defect is in that transfer, or the documentation of the transfer.
Well, in order for there to be a proper allonge, the allonge must be a part of the promissory note, and that's under 673-2041 of the Florida UCC. It's also explained in Taylor v. Deutsche Bank Trust, which is another 5th District Court of Appeals opinion in 2010, and Booker v. Sarasota, 1st District Court of Appeals opinion in 1998. They identify how a note is transferred via an allonge to note. It explains that the allonge must be affixed to the promissory note in order to transfer that document and be treated as an endorsement to that particular note. So the break in the chain is the failure to provide competent record evidence of the transfer from the FDIC as receiver for People's Bank to Hancock. The endorsement, it's our position, is invalid as a matter of law because it's not in compliance with either the Florida UCC or the case law.
Was there also an assignment of the mortgage?
Your Honor, that's a separate issue that we've raised under the heading of failure to provide competent evidence of standing. The assignment of mortgage that was provided was challenged at the lower level on a number of different reasons. First, it was not a properly authenticated document. I know that appellee's contention is that it's properly a self-authenticating document under 90.902 subsection 4. But in order for it to be accepted as a self-authenticating document, you must have a signature of the custodian of records, and in this instance, it would be the Office of Official Records in Orange County. You would have to have a sworn or certified statement on there saying that that assignment is what it purports to be. At that point, the court would have been able to accept it as a self-authenticating document. The document was not self-authenticating, and in fact, the deposition introduced for Regina Lawrence, which was Defense Counsel's Exhibit 1, they read portions of the testimony. It made clear that she was not a corporate officer of the FDIC, and it also made clear that the assignment did not bear an endorsement or common seal, which is required under Florida statute.
Is there a trial transcript?
Yes, there is.
That was filed in?
Yes, it was a supplemental.
Okay, it was supplemented
Of the record.
in the record, so we can see all that argument in the trial transcript.
Yes, and I do have specific provisions to help go through. The assignment drew several
That's what the
objections.
brief's supposed to do, right?
Yes, Your Honor. The assignment was challenged on a number of different grounds. The first was that it was not a properly authenticated document. The second grounds was it was attempted to be introduced as a business record of Hancock. The transcript will reveal that the witness who the appellees called to testify as to laying the business records predicate for that particular document did not have the requisite knowledge in order to lay the business records predicate under 90.803 subsection 6 of the Florida statutes. It will also establish, the transcript will also establish that the document was created by the law firm who was handling the matter for the plaintiff at the lower level appellee on this matter. It will also establish that Mr. McCraney, who was the witness, did not have personal knowledge as to the creation of the document and could not testify as to when, in fact, the document was created. As the court may be aware, 90.803 subsection 6 requires a predicate to be laid, and it must be a competent records custodian or otherwise qualified witness to testify to the creation of a document, that the document was created by a person with knowledge, that it was kept in the ordinary course of business, and it was their regular business practice to keep such a document. In this instance, the document that we're talking about was created and prepared by the law firm, not the plaintiff who testified in this matter. Mr. McCraney was not, as I understand, an employee or would have unique knowledge as to the matters that go on in the law firm that created the assignment of mortgage. So the first objection was an authentication objection. Then it was an admissible hearsay objection. I don't think that they got either the authentication correct at the lower level or the admissibility issue correct. We also, back to the allonged promissory notes, similarly, there was the first getting it through the door would be whether it's a valid allonge in any regard, and it's our position that the allonge does not operate to transfer any interest in the note mortgage because it's not an endorsement of the note at all. It's a file, it's a separate filing that was introduced as a separate exhibit. The second position is that it was not properly authenticated. It's not a self-authenticating document like a commercial instrument normally would be under 90.902 subsection 8 because the signature that purports to transfer an interest is not a part of the instrument itself. Finally, there was no testimony verifying that it was an authentic document, even if the court accepts my position that it was not self-authenticating. There was not additional testimony that verified or authenticated the allonge at that point. There was a question posed by appellee's counsel that asked for the authentication, but the witness's knowledge was expressly contained in the document provided to him at the time. He was able to read what the document was called, who it was from, and what it said. And when challenged on that on cross-examination by the appellant's counsel, it's pretty clear that the testimony could be confined to just what was on the document before him. We also have raised as a second issue on appeal that the appellee failed to provide competent evidence that it complied with contractual conditions precedent. There is a condition precedent that is articulated under paragraph 22 of the subject mortgage in Frost versus Regions Bank. It was accepted that the shall language contained in the mortgage document creates a condition precedent. As such, plaintiff's burden is to provide proof to establish by the preponderance of evidence that it has complied with the contractual conditions precedent when the issue has been properly raised. Here in the answer, the conditions precedent compliance was denied with specificity, so it properly placed the compliance at issue. The letter that was introduced was a document that was admitted into evidence as Plaintiff's Exhibit 1. You'll find that at the transcript, page 108. It was a document that was created by People's First Community Bank, not Hancock Bank. The witness who was called to testify was an employee of Hancock Bank. Candidly, Mr. McCraney, who was the witness for the appellee, was previously an employee of People's First Bank prior to the FDIC taking over and any subsequent transfer. But at page 103 of the transcript, a question was asked, were you a records custodian of People's Bank? And the witness told us no, and that's at 103. And he also confirmed that the document was created by People's Bank, but he was unable to testify as to the date of creation. Again, we asserted a hearsay objection, and we contended that it was not a business record, or at least the predicate had not been properly laid to admit that document in as a business record. And It's partially because the prongs of the business record predicate were met. The first being that he was not a records custodian of Peoples when the document was created, and second, that the date and time of creation of the document was unable to be verified by testimony. So we contend that the appellee failed to provide competent evidence that they comply with conditions preceding. Appellee.
Going back to the allonge, was there any argument made as to the validity of the allonge and the amended answer, second amended answer in the affirmative defenses?
Yes, Your Honor. In paragraph 4, they denied that the plaintiff at that time, Hancock Bank, was the owner or holder of the note mortgage.
That's not specific to raise that issue as a validity issue.
He also...
That's just a general denial.
Well, there was also in the second part of paragraph 4, he specifically denies the authority of Regina Lawrence to execute documents on behalf of the FDIC.
That's it. So there was no specific argument made in terms of the second amended answer and affirmative defenses specifically as to the validity?
Well,
just general denials?
And then a lack of standing defense that was asserted as affirmative
And I
defense.
asked you that question before, you said look at the transcript, and we argued it. Is it in the transcript or not?
Yes, the facial challenges to...
No, the argument that, did you argue to the trial judge and the trial transcript, and during the trial, I asked you that before, and you said, look at page 100, and that's where you argued it. So I'm going to look at page 100. You told me it was there in the transcript. Is it or isn't it?
Yes, the challenge to the allonge is there, and it was also raised in the pleadings. So I just want to make sure that we're talking about...
You've got just under 5 minutes.
Okay, then I'd like to reserve for the rest of my time now.
Good morning.
Morning, sir.
I'm Jeffrey Jontz, and with me is Eric Jontz, who participated in the preparation of our brief. I think, first of all, we do need to talk about the standard of review.
You're not related, though, are you?
We're not related, no. Just a coincidence. I do think we need to talk about the standard of review issue, because they're saying it's de novo, and really what they're arguing is that Judge Kamansky made errors in what he allowed into evidence. And from our point of view, the Lamar case and other case we cited, this is a clearly erroneous situation. Did Judge Kamansky err in what he allowed into evidence at the trial? So unless you find that he made an error in what he admitted into evidence or he abused his discretion, I think you are not in a position to reverse his decisions. I also think it's important to talk about what this appeal does not raise. I'm sure you've heard a lot of cases over the years involving MERS and other situations where notes have been transferred a myriad of times and nobody really knows who owns the note and loan documents anymore. That's not this case. This case was one failed bank that was taken over by the government. All of the documents concerning the takeover are matters of public record, can be found at the...
When did a transcript get filed in this case?
I'm sorry, what?
When did a transcript get filed?
I believe that the appellant filed it after, later on in the appeal. We didn't file it.
That's interesting because our notes indicate that there's no trial transcript, so we don't know whether the allonge invalidity argument was ever raised, but apparently he points right to the pages in the transcript. We need to go back and look at that. So apparently it must have been filed late.
I don't think we filed the transcript, so if it got filed, it would have gotten filed.
Do you know if the transcript's in the record or not?
I've got to be truthful, I don't know. I thought it was, but I would hate to have to swear to that. This case does not involve the admission of copies of a promissory note. We brought the original promissory note, which the FDIC sold to us and which we had in our possession, to the courthouse and introduced it into evidence at the trial. So this case doesn't involve some of the problems that have been involved in other cases with notes that had been sold 1 million times and nobody knew who owned them anymore.
So we have the original note, and so the issue really comes down to, and there appears to be no dispute that the government took over People's Bank. So the documentation, though, that transfers the note from the government as the custodian of the People's Bank to your client is this allonge. Is that correct?
Well, that's one of the documents. But in fact...
Well, what document was, excuse me, besides the allonge? Were there other documents introduced?
Yes. Do you have a copy of our brief that has the attachments to it? I mean, there's really an abundance, there's an excess of evidence based on the Supreme Court cases and your cases, because the first thing we did was we admitted the allonge. Now, he says that the allonge or the assignment has to actually be attached to the note, and we don't agree with that. In fact, there's really no place you could attach it to the note. It's a separate document. We introduced the mortgage, and then the third document to our brief is the allonge. And it's the document that assigns the specific note from the FDIC as receiver to Hancock Bank. It's a one-page document. It's attachment 3 to our brief. But then, that wasn't all we did. Because what happens when the government takes over a bank and assigns loan documents, like anything the government does, it's long and very complicated, and in this case, the purchase and assumption agreement is 122 pages long. And so we attached the first page, and then the last pages 39 and 40, and the signature pages. And this document also says, we, FDIC, as receiver of Hancock, are selling these assets to Hancock. So this is the second way we prove that we own the documents. Then if you go look at attachment 5 to our brief, we have a separate document called an assignment of note, mortgage, and loan documents, which was recorded in the public records of Orange County, and which is another assignment of all the documents, not just the note, but the mortgage and all of the related loan documents that go with it. So not only did we prove
Was that
that
document executed before or after the lawsuit was filed?
the documents were executed before the lawsuit was filed. Because the purchase and assumption agreement took place just a day or two after People's Bank was taken down, which was December 18 or 19 of 2009. And then the assignment and allonge were prepared by the FDIC and sent to our law firm to file in the public records, so the public was on notice that Hancock Bank now owned these documents. Now, how do these documents come into evidence? Well, the original note comes in because you're the holder, and you can show up and introduce it as the original. The other documents come in 2 or 3 different ways. They come in as a business record. Mr. McCraney, who had been employed by People's Bank and also employed by Hancock, testified that he had the original bank's file, that all these documents were kept in the ordinary course of business, they were relied on by the bank, and he introduced them as business records. But they also come in as government records, because these documents were signed by a public official and came in as public records. And I must say, Judge Kamansky, they're still self-authenticating under the rules because they're signed. They can either come in if they're under seal, or they can come in if they're signed by a government official, and these were all signed by a government official. And there's a provision in the rules which say unless there's some evidence that they're untrustworthy. And you'll find in the record, which I can't tell you whether it's been filed or not, several times Judge Kamansky said to Mr. Lejean, who tried the case, not this gentleman, do you have any evidence that these public records aren't trustworthy? Because after all, the government has an obligation to maintain them. Do you have any evidence that I should not rely on these documents as public records and let them in as self-authenticated under the exception to hearsay rule? And there was none, so they came in. So we've really, if you look at the Taylor case and the Gillian case and your own Deutsche Bank case and the Perry case, they really say that if you own the note, if you're holding the note in your hand, which we were, then the debt flows with it. the debt flows with it, and and you don't even really need an assignment. In the,
I thought those cases said, if you're the holder of the note, the mortgage lien flows with it, and you don't need an assignment of the mortgage.
well,
And that assumes that you're either the payee of the note, or that the note has been assigned to you by an allonge or some other sort of an agreement. I mean, if I find that, if I find a note payable to you on the street, I can't just show up and enforce it, because it's not a bearer instrument. It would have to be endorsed over to me, but I think those cases don't say that you just show up with a note and you're good to go. I think they say that if there's no assignment of mortgage, that's okay as long as you're the holder of the note. And the holder, I think, would mean the note is either payable to you or has been assigned to you.
Well, that makes a lot of sense, but the Gillian case back in 1938 says the transferee of a mortgage, which would go with the note, would be entitled to foreclose in equity upon proof of his purchase of the debt. Well, the purchase and assumption agreement is such proof. And then it goes on to say, notwithstanding lack of written assignment. So it says you really don't even need an assignment. Now, it's good practice, and good law firms do have assignments, and we've got one. We've got an assignment. But it says you don't really have to have one. And in your Deutsche Bank Lippy case last year, you say, this court said, therefore, standing is established because it is the note holder regardless of any recorded assignment. So I guess what I'm saying is, we
But I
probably...
think that case was referring to assignment of the mortgage, not an assignment of the note. The issue usually is that somebody shows up with a note that's either endorsed in blank or with an allonge, but they've never taken an assignment of the mortgage, and so there's a dispute over whether the lien follows the debt.
Right.
And I think that's really the proposition that those cases stand for, is that the lien does follow the debt, provided that you can demonstrate that you're the holder of the
Right.
debt.
And that's why good law firms and good clients have all these other documents, so you don't have to go into court and prove through testimony that you own these documents. So in this case, we hold the note, we got the original note, we got an allonge which says it was assigned to us, we got the purchase and assumption agreement which says it was assigned to us, and we got the assignment which says it was assigned to us. What more do you need? It's kind of like a belt and suspenders and a second belt. I do want to just turn for a moment to this question of the demand, because there is a condition precedent in these loan documents that say you got to send a demand to the borrower before you sue. And so what did we do? People's Bank, before it was taken down, sent a demand letter, and with a certified return receipt. And if you look at the last exhibit attachment to our brief, you'll see, which is attachment 6, is the letter which Mr. McCraney introduced into evidence as a business record of the bank, which was in the bank's files. But more importantly, if you look at the last...
letter.
I'm sorry?
The Hepner letter,
I'm sorry.
Sue Hepner.
Yes, the Sue Hepner letter. If you look at the last page, is a certified return receipt, and you'll see up there the signature is S. FORD-WHILEY. Well, that's Sarah FORD-WHILEY, and she admitted in her deposition that she got the letter and she signed the return receipt. So not only did Mr. McCraney prove it through the business records, but the defendant, through an admission against interest, was claiming that they didn't get it, said, yeah, I got it, and I signed the return receipt. So it came in as an admission against interest. So our point of view on this case is Judge Kamansky was pretty careful. Mr. Lejeune, the gentleman who tried the case, made just about every argument you could possibly make. Judge Kamansky listened carefully to the evidence. Whenever he was introducing these documents, he would ask, is there any reason why these documents are untrustworthy or shouldn't be introduced? He didn't hear any answers that he thought were good ones, and he introduced these documents. And our position is that unless he abused his discretion or was clearly erroneous in introducing these documents under the various evidence rules, his decision has to be upheld. Thank you.
Thank you, sir. You've got, despite what the clock says, I'm not sure why we're having a little clock issue today, but you've got about 4.5 minutes.
Okay, thank you. Just to clarify, after the initial brief was filed October 9, 2012, there was a motion to file supplemental record on October 15, 2012. There was an order granting that 2 days later, and the records were received and supplemented on the 17th.
That includes the transcript?
Including the transcript.
17th
of October. And it was also, we received a supplemental index of the record, which confirms volume 2 at the very last page. I believe the transcript's going to begin at page 685.
So the brief was written without the transcript.
And I think that might be a portion of why some of the citations in the initial brief were not to the transcript themselves.
There's no citations in the reply brief either.
And to clarify,
And there's nothing in the reply brief that, points you to, the transcript.
so again, the standard for proving standing is that the plaintiff must present evidence that it's the holder of the note. Under the Florida Uniform Commercial Code, that is either an endorsement in blank to it, along with possession of the physical original note, or a specific endorsement. Here, there is nothing that is provided along with the instrument. What Appellee's counsel is asking is for the court to, by operation of law, attach a separate filing to the original note, therefore creating an endorsement and transfer.
What law says that I thought the whole concept of an allonge was that it was separate from the note. I mean, is your concern here that it wasn't stapled to the note, or is it your concern that it wasn't specific enough, or is your concern that it wasn't executed by a proper government official?
My concern is that it's not affixed to the note, so it's not by operation of law an allonge to note. Therefore, it's not an endorsement. Therefore, there was not a proper negotiation of this instrument.
Refresh my memory again on what says that it has to be physically attached to the note.
Okay.
I guess I thought my assumption was that it was a separate instrument. If it wasn't a separate instrument, then how is an allonge different than just an ordinary assignment that typically you see just stamped on the note?
An allonge is not a separate instrument, it's just a separate piece of paper affixed to the promissory note or negotiable instrument. And that's, I think, where the rub is.
Where is the requirement? I know there may be some things that say it generally is affixed, but where's the requirement that if it's not affixed, stapled to it or glued to it or something, that it's no good?
The Uniform Commercial Code, Florida's UCC is 673-2041, subsection 1. It explains that for the purposes of determining whether a signature is made on an instrument, a paper affixed to the instrument is part of the instrument. The definition of an allonge is identified in Booker versus Sarasota, and again by this court in Taylor versus Deutsche Bank National Trust Company, and it says...
I'm sorry,
2041, subsection 1. And it explains that an allonge is a piece of paper annexed to a negotiable instrument or promissory note on which to write endorsements for which there is no room on the instrument itself. Such must be so firmly affixed thereto as to become part thereof. There is not a Florida court that has addressed the issue directly on point. We do cite in our reply brief, I believe, truly the only case that we've seen that addresses it, and unfortunately it's a Third Circuit opinion from 1998, and it evaluates whether you're a holder under the UCC Article 3, which Florida has a similar provision, which is what we use as our Florida's UCC, and it explained that the bank in that particular suit, which is Adams versus Madison Realty and Development, failed to prove that it was the holder because of the separate allonges. They were not considered endorsements to the note. What we're trying to contend is that because there are no endorsements to the note,
So if at trial, someone comes in, a party comes in and says, Judge, here's the original note, and then hands him the allonge, and it's not stapled to the note, you're saying that allonge is no good?
It's my contention that it's no good. I suppose that
Well, I
what,
guess they could take it and staple it right then and there, then would that make it good?
that probably would work out, but then you would be,
I guess that gets to the point, if it's not stapled or fixed, but the trial judge finds it's been appropriately executed, is it harmless error if it's not stapled at that particular time?
well, Your
I
Honor,
mean, they could go back, and if they were to buy your argument, they could go back and for another trial, take it to the judge, staple it, and then where are you?
well, I think what they would have to do is properly negotiate it under the Florida UCC, probably.
No, you're saying it's not stapled or fixed, and so that renders it invalid, so I guess my question to you is, they go back for another hearing, they take it in, staple it, and then that's it.
And then they would have to provide testimony that it has always been affixed to the promissory note, and I don't think they'd be
Well,
able to
but
do that.
you said before that if they were at a hearing and they handed the judge the note, and then handed him the allonge, and it wasn't stapled, but they staple it right then and there, that would be fine.
And I must have misunderstood, and I do apologize. If the
It seems to
instrument,
me, I mean, if the trial judge finds that it was appropriately executed and it's not attached to the note, although what you read there seems to indicate that it should be, but it's not, but the trial court finds that's the allonge that goes with the note, as a matter of fact, and maybe it would be harmless because it's not properly attached.
and I think there would have to have been testimony verifying or authenticating otherwise if it was not a part of the instrument itself, which there was no testimony to that effect.
Counsel, thank you, sir.
Thank you.
All right, thank you both. That will conclude our session for today.